right, we are going to get started. Kathy Wood is a tough act to follow, and usually regulation is boring, but in the digital space, it's never boring. We've got some fantastic panelists here, and the format of this is going to be, because we've got just some individuals with phenomenal experience, I'm going to kind of just go down and talk with each of them if they, see if they could share some of their experiences in the space with us, and then we will cover the topic of this panel and go from there. All right, so David, well, and actually let me have each of you just briefly introduce yourselves first.
Hi there. I'm David Oakland. I am a senior trial attorney with the Division of Enforcement for the Commodity Futures Trading Commission.
I'm Marco Santori. I'm the Chief Legal Officer at Blockchain.com, which is one of the oldest and largest crypto platforms, and we're, of course, best known for our wallet, which is the largest in the world, over 45 million of them all over the world.
Yusuf Hussain. I'm wearing two hats here. First hat is I am the head of risk for Gemini, which is a crypto exchange and custodian founded by Cameron and Tyler Winklevoss. The second hat that I'm wearing here for purposes of this panel is that I'm the president of the board for the Virtual Commodity Association that is looking to obtain SRO designation. We'll get a little bit more into that. Also, thank you for the organizers of the event for putting the exciting topic of regulation at the front of the agenda while everyone's still awake.
My name is Ben Reynolds. I lead corporate development at Silvergate Bank. We're based in San Diego. A lot of people know us as the crypto bank. We've actually been in business for over 20 years and just have been doing crypto since 2014. But my responsibilities there are around strategy and product and growth.
Great, thank you. So David, I would love to start with you. And there's a bunch of things I'd love to touch on. So you've been involved with some pretty interesting cases, so I'd love for you to touch on those. I'd also be curious to hear your thoughts about the importance of the CFTC allowing the self-certification of CME and CBOE Bitcoin futures. I'd love to hear about Lab CFTC. And then I know one thing that we talk about quite a bit is, the need at some point, and we'll talk about the VCA, but whether it's through self-regulation or an organization like the CFTC stepping in and taking over jurisdiction of the spot market instead of just derivatives on spot commodities. So if you could touch on all of those, that would be great.
And so before I touch on anything, let me start off with the basic statement that hopefully every time you see someone from the federal government speaking on a panel like this, they say, which is that the views I'm going to express today are not those of the CFTC or the Division of Enforcement or any of my supervisors. And they might not even be my views, honestly, because oftentimes I find these things to be so interesting because I learn something new that forces me to rethink a little bit about things that I've already learned or I believe I've learned. So I really appreciate the chance to be here. To give you guys some background, I'm an attorney. I went to law school out in California at Berkeley, ended up in New York working for a large law firm, a white-collar boutique. I clerked, and then went to the CFTC. When I got there, it was the mid-2000s, so there was a lot of focus on physical commodity manipulation issues, natural gas, crude oil, but also a lot of financial regulations, on top of the other things that the CFTC does, which is monitor the intermediaries that service the derivatives space. So FCMs, swap dealers, and the exchanges themselves. I first became involved with the virtual currency space around 2013 or 2014. Our very first, I would say, action in the space was a administrative settlement that occurred in 2015, but all the activity was really, I think, in early mid-2014 with a outfit called CoinFlip that was operating an online platform called Derivabit that was intended to offer essentially swaps on Bitcoin. And it's no surprise that you can't do that without registering. It's very straightforward. It was a very simple case, but it was important because the commission had to actually find that Bitcoin and other crypto assets that were working as stores of value or methods of exchanging value were commodities. And that was an important decision. It wasn't really, everyone's like, it was a really big decision. I don't think it was actually that hard given the text of the act. But it was an important thing to get out there. FinCEN had already come out with some of its guidance on what it expected of money services businesses. So it was a very easy place to go for the commission. Since then, I've been either directly involved or as part of being a member of the Virtual Currency Task Force within the Enforcement Division, familiar with a number of the actions that we've brought in this space. To give you like an example of that, we've had a number of what we'd call retail fraud cases, including coin drop markets, the Dylan Dean case. For those of you who are in Boston, there's a pending case that's I think maybe stayed currently called My Big Coin. And then also more recently, a larger sort of multi-level marketing kind of Ponzi scheme called Control Finance. And those are cases where essentially the victims are really retail investors that for whatever reason were induced to part either with their cash or with their Bitcoin or Litecoin for some kind of belief that the person they were giving these assets to were going to be able to trade them for their benefit. Sort of more in the industry space, again in the fraud space, there was the Kim case out of our Chicago office where a trader for a Chicago trading firm was surreptitiously diverting Bitcoin out of their coffers to his own wallets. And then last year I was involved in bringing a case against someone named Mr. Thompson, who was operating an escrow service between OTC traders. So, we've been in the fraud space now for a few years, working on those cases. On the industry side, I guess you would say, in addition to CoinFlip, we there was actually an unfortunate case involving a registered Terra, and also a settlement with Bitfinex relating to how they were handling their margin trading. So that's sort of the universe of, or there might be a couple other cases out there in the retail fraud area, but that is sort of the kind of cases we're currently bringing. So there's some that are, I think, what you would say clearly in the derivatives world, and then especially with the move to the self-certification of contracts, we have had a push into the spot market and exercising our anti-fraud and anti-manipulation jurisdiction.
Yeah, and that's a helpful distinction that I should have made. The CFTC does have oversight with respect to fraud and manipulation in the spot market. And then, of course, if there's any type of margin financing for retail participants. Do you think that the CFTC will ever take over full oversight of the spot markets?
Certainly without speaking for anyone in our headquarters offices, that's really up to Congress. And I think that's a big decision for Congress to make. First of all, it'll be kind of a recognition that the spot market really should be treated as a financial market. Mm-hmm. That's what we are. We are a financial regulator. And admittedly, it's always hard to think about that when, our cases are always like the Kraft wheat manipulation, where it's about, various kinds of wheat and the grades of wheat and things like that. But ultimately, it's about the stability and the utility of our financial markets to hedge risk. And, I don't know whether Congress would want us to be that role. Certainly you could argue the FTC would be another locus point for that.
We'd prefer you.
Thank you. But, we're a very small agency. And I think to adequately be able to handle day-to-day registration oversight, or even supervising an SRO in that space, would be a substantial scale up of the mission statement of the CFTC.
And different participants acting in the two markets. You've got more, I would say, institutional participation in the derivatives markets and more retail, which is, it sort of feels more in the SEC's world, kind of overseeing retail. There's plenty of retail though in the
There's plenty of
derivatives commodities
retail.
markets. Yeah.
It's really, I think, kind of the nature of what is a spot market there for. You know,
And the pig farmers may get upset if they think you're going to oversee pigs.
right. I mean,
and
you know,
wheat.
I mean, they're so closely related, though. It'd be very easy to say yes, it falls into your bailiwick, and certainly, for example, currently the House Ag Committee voted on a CFTC reauthorization bill with certain amendments to our underlying statute. And it only spoke to digital assets in a really minor way. It was essentially to require us to promulgate rules, which is kind of strange given you would think Congress's general deregulatory attitude. But it would actually require us to promulgate rules guiding the exchanges as to how they would get access to the spot markets that set the price reference points for digital assets. And it seems like a very backwards way for us to be doing that, but it's actually something that we're already doing. So you mentioned earlier the self-certification process. You know, I know most of you are somewhat familiar with futures exchanges, but a quick background for those who don't. In the United States, the way a futures contract comes to market is essentially the exchanges that are currently registered with us, you know, and they're fully designated as contract markets, have fairly broad authority to promulgate a new contract. And they essentially just tell us that they're going to self-certify a contract, that they've done the appropriate analysis, that the contract will satisfy the various core principles that are in our act. And then, I mean, I think depending on the kind of rule, whether it's a new contract or a modification of a contract, it essentially can go live within a few days or a week, maybe at most. Now, in practice, when something is as novel as Bitcoin, there's a little more interaction from the exchanges. They really want people at the commission to be aware of what's going to happen and gauge industry interest and explain who are the stakeholders and things like that. But as part of that, obviously, there are provisions where the exchanges are going to have access to the spot markets that are giving them reference points. And obviously that's extremely important for the surveillance capacities of the exchanges. If they can't know whether a player in the futures market is building up a position in the spot market, then they're going to not be able to identify whether the person is trading appropriately or perhaps doing something that's distorting their marketplace. So I would say the commission's already doing what this bill is proposing. It's just requiring us to do it now in a more formal rulemaking way. And you know, whether that's good or bad, I think that's for Congress to decide, but it's already happening. So I think that's...
Thank you. Yeah, that's helpful. So it's probably most natural to go over to you, Yusuf. So of course, the Chicago Board of Trade and our exchanges in Chicago all started with self-regulation. And it wasn't until later that the federal government stepped in to provide oversight. And I think for a while, we've been talking about the need initially for industry-led self-regulation and then, you know, maybe more formal self-regulation for the crypto markets. And that's obviously an initiative that Gemini has spearheaded with the VCA and now has a consortium of exchanges. It'd be great to hear you talk a little bit about that. And then I'd be curious, you know, what type of, you know, if you're looking to become sort of a more formal SRO versus like an industry-led SRO, what type of certifications or approvals would the VCA need?
Absolutely. So for the reasons David stated, the case law that he stated, the underpinnings of self-regulation are purely for customer protections, right? So we think that regulation will drive mass adoption, will give comfort to the regulators and these institutional investors that are regulated by the very same regulators as the CFTC and being the CFTC and the SEC. So we take an approach where if regulation is going to help drive mass adoption, can we pull together traditional financial industry subject matter experts and crypto industry subject matter experts to pull together a sensible, thoughtful approach to regulation in our space? So just taking a step back, in 2018, early 2018, former Chairman Giancarlo at the CFTC had publicly stated that the crypto industry should consider self-regulating itself. Specifically, the self-regulation that I'm speaking of is the spot market. It's the underlying that the futures and derivatives are built off of. There isn't any spot market surveillance, spot market regulation for commodities in general, and this is a shift in the way we think about things, where spot market cryptos are considered that are considered commodities will be regulated in some way, shape, or form. So when Giancarlo stated that they're looking for some sort of self-regulation, industry pulls together. We thought it'd be a good idea to pull together a couple of different exchanges and create what's called the Virtual Commodity Association, the VCA. Primarily commodities, because 80-some-odd% of the volume over the past year has been within commodities: Bitcoin, Ether, Litecoin, things that are considered crypto commodities. Fast forward to the summer of 2018, the SEC had delayed a number of decisions on ETFs, Bitcoin ETFs, citing lack of liquidity and concerns around market manipulation. In September of 2018, we formally launched the VCA with a number of different exchanges, and we announced 6 committees that will be addressing the concerns that were highlighted by the regulators. Once again, all for consumer protection mechanisms that that investors have seen in traditional finance, and bringing that same level of consumer protection to crypto. We're primarily focusing on the SEC and the CFTC's concerns around market surveillance. We're a truly global market. We are in a market where you can send assets from one exchange to another. You can't do that with stocks, for example. Market surveillance within one platform isn't sufficient enough. We need cross-market surveillance, especially if futures and derivative contracts are being built off of spot market pricing. So a heavy focus of the VCA is implementing cross-market surveillance capabilities, very similar to how FINRA has their trace cross-market surveillance capabilities. We're looking to see if we can build that out for once again, the crypto spot commodities. We've been working very closely with the CFTC and the SEC. I think there's been a lot of great progress over the last year or two. In speaking with Commissioner Quintens at the CFTC, he indicated that it took the NFA about 7 years to be designated an SRO by Congress, right? The CFTC acknowledges that that regulation in the crypto space also needs to move at the pace of innovation. Hence why I believe they're looking for the industry to self-regulate itself so that we can keep pace. Additionally, as part of the reauthorization, we had some really interesting conversations. We were hoping for more in the reauthorization, but we understand exactly why it was pared back. But it was very promising to be part of the reauthorization conversations of the CFTC to expand scope, expand budget. Additionally, what's interesting is the SEC had delayed a number of ETF decisions on ETF proposals and rejected one. And the conversations that we've been having with the SEC FinHub, with Val Stepanek, they've been sending the ETF, the organizations putting forth these ETF proposals to the VCA to discuss how we can effectively do cross-market surveillance. So a lot of focus on cross-market surveillance, but broader. We're looking at things. The VCA is looking at things like appropriate security and custody mechanisms, because custody in our industry is fundamentally different than custody of fiat and stocks. We've got BSA AML committees in place. We've got we're trying to figure out how we can have an enforcement or examination in place. 2 underpinnings for an SRO is in market surveillance and making sure that you've got appropriate enforcement and examination capabilities. So a lot of the conversations with the CFTC is, great, you're looking at doing all of these things, but how are you different from another standard setting body? And how are we different is we're thinking about how we can enforce and examine for member institutions. There's a couple of other committees like insurance, tax, but primary focus on cross-market surveillance. Your question earlier about what would it take? Would it take congressional approval? Absolutely. The intent of working with the CFTC and the SEC is so that we can be in lockstep with them, and they could be proponents of an SRO model. I think there's been good traction in the regulatory space. The Crypto Act of 2020, a bill was proposed. Fairly obvious for folks in the industry, but it set forth that the SEC will have some governance oversight of crypto securities, the CFTC will have oversight over crypto commodities, and FinCEN would have oversight of cryptocurrencies. An SRO does not eliminate the need for the CFTC. An SRO in the space will still be governed, and oversight will be provided by regulatory authorities like the CFTC and SEC. So it's complementary to existing regulatory frameworks that are in place.
Great, thank you. That's helpful. Marco, you are probably one of the earliest lawyers in this space. We certainly appreciated the innovative structure with the SAFT, trying to find a way to work with regulators in this sort of new era. You are now president of blockchain.com, and blockchain.com recently launched the Pit, a new spot exchange. I'd love to hear more about what type of assets you're listing, what type of assets you think you'll list in the future. I guess another self-regulatory component here is the Crypto Rating Council. And I'd be curious how you view the framework that they've put out, if you think the Pit will sort of be using that to help determine what assets to list. But yeah, all of that stuff.
Sure. Blockchain.com is one of the leading crypto providers in the industry. We've been around for a very long time, since just about the beginning. I've been the company's lawyer since 2014, early 2014, and I joined full-time just a couple of years ago as the president and chief legal officer. I'm sure at some point we'll find a full-time president to do real president stuff, but until then, I'm the best we got.
They're very lucky to have you.
Well, thank you for saying that. And so we're best known for our wallet. Over 45 million wallets all around the world. They are self-custodied wallets, meaning you hold your crypto. That's kind of the point of all this, unless you're just trying to turn your dollars into more dollars, which if you are, no offense, this is a good room to be in. It's probably a productive place to be as well. The blockchain wallet does a little bit more than that. It enables you to be your own bank, which is a phrase that is very well known. We have a registered trademark for it. It's one of the few really good pieces of IP we're proud of. In any event, that's what we're best known for. But a year or so ago, we started along our path to building what is now called the Blockchain Exchange. We launched a project called the Pit, Performance Intensive Trading, Performant Intraday Trading, depending on who is sending us a nastygram for trademark infringement. And no, nobody? Okay, just for the lawyers. Thank you. See, the lawyers, that's what I said. Once it's in beta currently, it'll be launched out of beta very soon. I encourage you to take a look at it. Some of you will be able to use it, some of you will not, depending on your home jurisdiction. But it's the fastest exchange in the world. And right now we list major assets and assets that we think are going to be successful, meaning not necessarily the ones where I think the price is going to go up, but the ones where we think there will be real community-led support, the ones that we think are good long-term bases upon which to build real financial ecosystems, and sometimes non-financial ecosystems as well, lest we forget the West Coasters, right? So we've launched the Pit. We're bringing it out of beta soon to be called the Blockchain Exchange. You'd asked what sort of assets we list, and really those are the kinds of assets that we believe in. There's been a bit of a recent attempt at industry self-regulation via what's the name of it?
Crypto Ratings Council.
The Crypto Ratings
yeah.
Council, which, if you follow me on Twitter, I called Hot or Not for crypto. Some of us remember Hot or Not from our younger days. I had no business being on it. But really, that's what it is. It is it is a website. You can go to it now, Crypto Ratings Council. You can take a look. They list a number of different coins and give their opinion of whether this coin is a security, or rather how likely it is to be a security. Here's the thing, and the best way to view this is that it is just an embarrassment to the crypto industry that we need something like this, and at the same time, it is the absolute best we have. So I'm torn on this point, and that we have so little guidance from regulators, and so little guidance from the courts, and even less guidance from Congress as to which of these assets deserve investor protections versus which of these assets deserve consumer protections. That the best that we can do is something like the CRC, which didn't publish its framework even for rating these things. And one of the things they rated was Telegram's token as a sort of a middling chance of being a security. And then, of course, not 72 hours later, the SEC announced an enforcement action against Telegram, which isn't to say that the CRC was wrong. It's to say that, well, there's really no way to tell, and something like the CRC is the best we have. So I applaud the effort, I do, but I think it's a symptom of the wider confusion among entrepreneurs, among regulators, and among the bar, which is maybe the saddest part, is the bar itself. The lawyers are, by and large, uneducated on these points. They're giving either far too conservative advice, sort of walks like a duck, smells like a duck, must be a security type of advice, which is sort of your first hint that the lawyer you're talking to hasn't really looked closely at this stuff. And then all the way on the other side of the spectrum, where you have lawyers who are, and in one of the SEC enforcement actions, we had a lawyer who was an entertainment lawyer and never really touched any securities law, any securities laws in her history, as far as we could tell of practice, giving legal opinions on what is and is not a security in the world of crypto. So you have this wide spectrum of confusion among the bar, which is, of course, a larger symptom of a lack of guidance from the bench and from the government. So something like the Crypto Ratings Council is frankly a laudable effort.
Yeah, agreed. I think the more the industry can step up and try to self-regulate, and with these, the new asset, new technology, I think it's hard for regulators. So the more and then, you don't want a situation where the industry hasn't done that, because the regulators inevitably come in, and ideally you'd want them to adopt the best practices and standards that the industry itself knows it needs.
Absolutely. So we did this in the Delaware Blockchain Initiative, for example, which is one of the early, in fact, is the reason why we can have securities on a blockchain today is because of the Delaware Blockchain Initiative. There was a small group of folks who went to Delaware and worked with the Corporation Law Committee of the Delaware Bar and the legislature itself to pass new amendments to the Delaware General Corporation Law that allowed corporations to use a blockchain, to rely on a blockchain as their books and records under Delaware Corporation Law, which was just sort of this mind-boggling shift away from the typical perception of these requirements, but legally speaking, didn't really change anything. And that was the result of Delaware taking a descriptive approach instead of a proscriptive approach to regulation. And now corporations can issue blockchain stock, and that's not something that was available before.
Great. So Ben, I get to save my favorite here for last. I'm biased.
Wow.
We're a customer of Silvergate. We're also an investor. Silvergate started out as a traditional commercial bank in Southern California. And in 2013, I think I've heard Alan, the CEO, say that, he looked at this technology and thought it could be disruptive to banking. And the best way to kind of dig in and learn about it would be to start banking some customers in the space. Well, fast forward to now, you've got over 750 digital and fintech customers, and you IPO'd Kathy, Silvergate Bank, now a public company. So, yes, awesome. Excellent. But obviously, I'm speaking to the choir here, but everybody knows that one of the most challenging aspects of starting up in this space is a solid banking relationship. And in order to get to where Silvergate is, you clearly had to have a lot of discussions with regulators along the way. So I'd love for you to talk with us about that.
Great, thanks. Yeah, so in 2014, when Silvergate decided that they wanted to enter the space, we, just as Colleen said, we couldn't do that, or we wouldn't do that without regulatory approval. And so Silvergate is regulated by the DBO in California. We're also a member of the San Francisco Fed, and we're regulated by the FDIC as well, and now the SEC. So back in 2014, really walked through the front door of the Federal Reserve and said, we're Silvergate. We want to bank these companies. Their primary business is Bitcoin exchange. These are the risks, and this is how we plan to mitigate the risks. And as regulators do, they didn't tell us no. Right? So you're never going to get, hey, that's a great idea. You should go do it. But they didn't say, well, you can't do it. And so we started very slowly, really built the compliance framework for banking these firms in a safe and sound way in 2014 and 15, and then decided to grow it in 2016. And so that's about the time that I started at the bank. At the time, we had 15 clients. Today, or at least as of Q3, we had 756. And we kind of took a fresh look at the space and went out to our clients and said, yes, we're a bank, but that's not going to create much of a moat for Silvergate. I'm sure you have other needs. Tell us about your pain points. How can we help you out? And we heard the same things over and over again, which is, I spend 60% of my day managing my banking relationships, sending money around the globe. Liquidity is a challenge. Having the right amount of capital on the right exchange at the right time means that I have to have a bigger balance sheet than I should have to have. And there's this concept of counterparty risk. And so we took that and we built what today is known as the Silvergate Exchange Network, or the SEN. And if you happen to read our prospectus, we talk about it there in detail. But really what it is we've created, essentially a network effect where on the one side you have the exchanges, folks like Coinbase and Gemini and Kraken and Bitstamp. And on the other side, you have all of the institutional investors. And so it's not a blockchain solution. It's simply the ability to move US dollars around the globe 24 hours a day, 7 days a week through an API. And so because it's connected to the exchanges, at least the regulated exchanges, you can move money on nights and the weekends. One of the interesting things about this from a regulatory perspective is that, they didn't say no. Well, it's now 2020. The regulators come in every single year to do their exam, and we've now been through 6 exam cycles. We can't talk about those exams per se, but suffice it to say we wouldn't have been able to build the business the way we have, and we wouldn't be able to go public if our regulators weren't comfortable with what we're doing. And so we're actually very optimistic and kind of hats off to the regulators for really trying to understand what it is that we're doing and why is it important. And we've gone through that same, just as I mentioned, walking through the front door of the Federal Reserve back in 2014, we've done that every step of the way. So we did it before we launched SEN. You might have seen an announcement a couple weeks ago. We launched a product called SEN Leverage. This is the ability for our institutional clients to use an exchange partner to essentially take a loan on Bitcoin. So we're pretty excited about that. We think that there's a sort of a lack of institutional credit products out there. So we're pretty excited about that. And then, kind of shifting gears to the IPO, the prospectus was 400 and something pages long. And obviously the SEC looked at that, had an opportunity to comment on that, and we launched the IPO in November. So Silvergate is about a $2 billion bank, so pretty relatively small. And the roadshow was interesting, to say the least, because Silvergate is a little bit of a platypus. We have about 1.2 billion in deposits from crypto related companies of a $2 billion balance sheet, so very heavily concentrated. But on the asset side, it's half in kind of traditional banking products such as commercial real estate. We have some mortgages, some mortgage warehouse, but the other half of the asset side of our balance sheet is really like just holding it in securities and cash. And so you can think about the matching of these crypto fiat deposits and whatnot. But it was interesting as we were out on the road and we were talking to investors, because you could see that people really wanted to understand the crypto element and also wanted the safety of the bank element. Since the IPO, the stock has traded fairly well, but as you look at it, it's still very much a bank valuation. And when you look at what we're doing with SEN and SEN leverage, you can tell that it's really like the investor side of things is still doing the research and trying to figure it out. So, but the regulator side of it has been, at least from our perspective, actually very refreshing.
Thank you. Do I have time for one quick one? Okay. Unfortunately, we're running out of time here. I have like 9 million questions I'd like to ask, but just curious down the line, we're in an election year in the United States. It's going to be interesting. Do you foresee any big regulatory changes this year in this environment? And we have to go quick, unfortunately, but.
Certainly not at the federal level.
Yeah.
Although
really
I'm
quick.
always heartened to hear state regulators doing so much, especially getting used to custody and things like that. And I think that's where the real movement forward for a lot of these things are going to be, is the continual comfort level and in management of those custodial relationships, because that's ultimately driving so much of the financial trading side of it will be like comfort in the custody.
I think we'll continue to see innovation driven by competition, which is to say, at the state level, we've seen that on and off over the last few years. First with the Delaware Blockchain Initiative, then Illinois sought to catch up with Delaware. Delaware's efforts slowed down. Illinois did what they wanted to do in terms of their blockchain task force. And most recently, now we see Wyoming vying for crypto businesses with some very innovative they have a new bank charter. There's new rules around the Uniform Commercial Code in terms of how transfer and title and custody is transferred in digital assets. And you see that happen at a faster pace on the state level because there's real competition. And we really don't see much at all happening on the federal level until there's competition, right? We saw Facebook's Libra project actually spur the federal government to some action. Why? Because there was real competition with government dollars. So until we see more of that, we'll probably see very little from the federal government.
Over the past couple of years, you've seen federal and certain state regulators get up to speed on crypto. I think that maturation and understanding is going to continue to happen. The election is the wild card, but if we see another bull market, we see significant market dynamics change, that will definitely get the attention of regulators and focus on regulation in the space.
Yeah, I would echo what the group said. I mean, I think it's on the innovators to bring it to the regulators to sort of force them to look at it, if you will. One of the things to keep in mind, right, are that examiners and regulators are people too. And if you think about the way that they're evaluated, they're trying to preserve, consumer protection, the government in case things go bad and whatnot. So they don't have a lot of incentives, like when something works out well, like a Silvergate works out well, no one goes to the regulator and says, hey, high five, like great job being like so innovative and being the examiner on, on Silvergate. And so, it really takes a lot of, I think, courage on, if you're an examiner on the regulatory side, to stand up and say, you know what, we want to do the right thing for an industry, for the country. And there's a lot of potential downside risk to them and not a lot of upside. And so because of that, I think it's on the innovators, it's on the investors, it's on the people in this room to bring stuff to the regulators. And what we've seen is that they'll be very reasonable and are, a lot smarter and understand this stuff a lot better than people give them credit for.
Awesome. Thank you.